Hello ladies and gentlemen, welcome back your lovely faces to a brand new video here on the channel. Now, I'm not here for the next couple of days, so I've already made these videos just for you guys, so you got stuff to look at while I'm not here. I'm currently in the field with 20-odd thousand other people screaming at heavy metal bands. So that's where I am. I hope the weather is great. But yes, so what we're going to take a look at in the next couple of videos is the 995-page document, The Motion in Limine. Oh, guys, this is going to be a good one. But as you saw the disclaimer at the start of this video, we are not reusing content. This is for commentary, for criticism, education, and research. So if anyone would like to come forward and say anything, well, this is exactly what we're doing under the disclaimer under Section 107 of the Copyright Act, so nothing can happen for it. And again, this is not targeted at anyone. We are just going to be reading court documents. So let's get into it. So this is the first, obviously the first page, folks. This is what we got. Circuit Court Fairfax County. As you can see, this is filed on March the 22nd of this year. Obviously, it says it, confidential and sealed, but we did hear that Judge Penny, she did actually say to him, if you want to appeal, the documents need to be unsealed. So that's what has happened. So we're going to go into them. We got the table of contents, ladies and gents. Obviously, attachments, standards, the argument, any evidence, going through it all. But I thought we'd just start at the very, very beginning. And we'll get a few things. And if we see anything we like, we'll do a longer talk on it. So as you can see, we got a lot of transcripts and stuff going down. Then we got the legal standards of what they want to do. And now we get into the argument. The statement from the headline from Washington Post should be excluded and redacted. In ruling on the demurrer, former Chief Judge White held that 3 statements from the op-ed may be potentially defamatory and therefore survive demurrer. At the demurrer stage, all allegations of the complaint are taken as true, and Mr. Depp asserted that AH made the statement in the original headline of the op-ed. As you can see, it is by there. And this one was brought up, but if you remember, Lawyer Rottenborn, he did bring up the one that was put in print, not the one that was actually put onto the internet, which was completely different, the one in print. So, as you can see, that has to change in the last part of it. There is only one instance of AH referring to this, and that was in the body of the op-ed. Like many women, I had been this and this by the time I was of college age. And it goes on about the op-ed. The court did not find that statement to be an actionable statement in Mr. Depp's complaint. After all the evidence has been taken in the case, Mr. Depp, who bears the burden of proof, cannot establish through any evidence that AH made the statement in the headline. AH has testified that she did not write the headline and did not see it prior to publication. Now we got this by here, when obviously Ben Chew. Now, let's go through this. The version. This percent of the op-ed is entitled, I spoke up against this, faced the culture's wrath. That has to change. What are you referring to there? Who wrote the title? I'm not sure. But you approved the title, correct? I never saw the title before it was printed or went to press as far as I can recall. Moreover, the evidence is clear the ACLU submitted the article to the Washington Post for publication without any headline. At 4:23 p.m. December 18th, 2018, the op-ed was sent back to the ACLU from the Washington Post editors for finalization, without a headline. It was approved, still without a headline, at 5:54 p.m. and published online approximately 4 minutes later. There is absolutely no evidence that AH drafted, was aware of, approved of, or even communicated about a headline to the op-ed with the Washington Post at any time, let alone in the 4-minute window from the time of approval by the ACLU of the drafter's publication. In addition, the ACLU corporate designee testified that the Washington Post drafted the title of the article and it was not approved by AH or the ACLU. Now we got a few more of the transcripts. By Ben Chew. Directing your attention to the title. Who came up with the title? Based on my investigation, I'm not aware that the ACLU had any role in writing the name of the op-ed piece, and my understanding of how op-ed pieces work is that the media, in this case the Washington Post, would have drafted the name of the title of the op-ed and not the person who wrote the op-ed. Did the Washington Post seek the ACLU or AH's approval of its title? I believe the answer to that is no. There's nothing in the evidence that shows that they reached out to us to do that, and it is inconsistent with my understanding that these news outlets do not usually ask for the permission of the author of the op-ed to, for when they come up with the title. Now, obviously, when we had the actual trial, Terence Doherty was there, the guy from the ACLU, and, well, he said yes, they knew the title. This is what was going forward. They tried reeling in all this stuff about Johnny, even though they wanted to put a few things in there of him, but they were, we shouldn't. Their lawyers said that. But it was actually Amber and her team who were like, no, we want more of this, more of this, more of this. So that's why the title was actually allowed into the court case. Now it does go on about, attachment 71. Terence Doherty, even Mr. Depp's expert, Richard Marks, agreed that in the newspaper business, they usually have someone on staff write the headline, if you will. Attachment 85. There is no evidence that Mr. Depp can proffer that would establish AH drafted the title of the op-ed, was aware of it before publication, or approved it. Instead, the only evidence is that she did not. The burden of proof is on Mr. Depp, and they are unable to present any evidence to support the position on this statement. If you remember as well, they actually made she actually republicized it. She's the one who went on Twitter and she sent the link and she wrote the headline. This is what I wrote. That is the key thing there, and that is what they allowed into the court. Therefore, the statement in the headline should not be considered by the jury for defamation, and the headline should be redacted from all evidence submitted to the jury and should not be considered in evidence. Now, as you can see by here, we're going into number 2. Any evidence, testimony, or allegations of criminal conduct against AH should be excluded based on Virginia's rules of evidence and relevance. Now remember, a lot of these documents, especially this one here, when it's 995 pages, there's going to be a lot of stuff in here which is going to go over the same thing twice. Throughout this case, and as explained below, Mr. Depp has repeatedly made various allegations respecting conduct of AH to prove she is a liar, and claims that she has been convicted of or has engaged in criminal conduct, and has repeatedly referenced and attempted to insert them into the case, as if they establish that AH must be lying about this at the hands of Mr. Depp. However, in Virginia, only the fact that a party in a civil case has previously been convicted of a felony or a misdemeanor involving moral turpitude, and the number of such convictions may be elicited during examination. Now, in these documents, it does come out that AH, she is the reason that one of her friends is no longer on this earth. She was driving a car and that happened. That was obviously, they didn't bring any of that into it. Again, I can see it hasn't got anything to do with this. Even though people will probably come and say, well, it shows that she's a dangerous person, that she's a liar. Maybe. But it's got nothing to do with the case. Remember, this is all about the op-ed. That is it. Nothing else. We were saying about this during the trial as well, because a lot of people were getting heated at a lot of us when we were saying, well, this has got nothing to do with the trial. If you remember, myself, Linda, Les, we were getting quite a bit of heat from people in the chat because of this. So we got to remember what this was about. Obviously, it says there about, obviously, now going on. However, in Virginia, going on, in no event may the details of prior convictions be elicited, unless offered to rebut or other evidence concerning prior convictions. Despite Virginia's clear rules on this type of evidence, Mr. Depp has repeatedly attempted to obtain discovery of matters far outside of the parameters of this rule, to do this to AH, including serving extensive third-party discovery. First, Mr. Depp seeks to introduce evidence related to an arrest at the Seattle Tacoma in King County, Washington, in 2009, where she was arrested and quickly released. She wasn't quickly released. She was there overnight. And the charges was against her ex-wife now, if you remember. And if you remember as well, she came out and said the only reason that she was arrested was the arresting officer was homophobic. The arresting officer is a huge part of the gay community in the area where she did arrest Amber Heard. So that kind of backfired on her. So, going on, we got... Oh, no music. So press the wrong button there. They were dropped and the arrest record was later expunged. Well, it wasn't actually expunged because it's still there, but... You know, they were dropped and the arrest record was, you know, okay, whatever. It is undisputed that no criminal charges were ever brought against her in King County, let alone resulting in a conviction. But she did have to face a judge. Therefore, evidence, testimony, or references to this arrest or the underlying alleged conduct are inadmissible pursuant to the Act here, and also the details underlying these charges may not be elicited by Mr. Depp at trial. Again, totally understandable because it's got nothing to do with it, but people will say, well, it's about this. It's all about the article. That's all it was, if you remember. Now, it does go into Australia, the Australian incident now, which is really interesting, obviously bringing that into it, and around the time of what happened over there. Second, Mr. Depp also seeks to introduce evidence related to an incident involving AH's customs declaration in 2015, when she and Mr. Depp brought their dogs into Australia while Mr. Depp was filming Pirates 5. Again, to suggest that AH has a criminal record and is found to be dishonest by a court. Again, this is Elaine. We know exactly what Elaine and her team were trying to do, but this never, you know, this wasn't it. He just brought it up to say, well, she did it without my knowledge. Obviously going on, found to be dishonest. As with the King County matter, there is no conviction recorded because the Australian court instead discharged the person without proceeding to conviction. Now it goes on again, obviously the UK trial. Relatedly, testimony emerged in the UK trial when a third-party witness, an employee of Mr. Depp, claimed AH asked him to make false statements in the Australian proceeding, but he refused. AH denies this, but since she never even had a conviction recorded in Australia, the testimony falsely accusing her of attempting to manufacture testimony is also inadmissible. Thing is, though, we've seen the emails and the text messages regarding that. They were brought up in court anyway. Such evidence should also be excluded as irrelevant to the issues at trial, and any possible relevance is far outweighed by the potential prejudice. The notion that signing an airport form relating to the immunizations of Mr. Depp and Miss Heard's dogs suggests she is lying about being this by Mr. Depp is untenable. That's not what it was, you know, that's not how it was. But again, no, this is how she did it. Now it goes into Kate James, which, obviously, this was a bit of a huge thing. Third, the UK trial and a witness, Kate James, AH's former assistant, who was fired by her, designated by Mr. Depp for this trial and on this subject, included testimony related to Savannah McMillan, an assistant to AH, while she was filming in the UK, and the status of her employment relationship with AH in the United States. She provided a letter to the Immigration Department in support of her in 2014 after Miss McMillan had been stopped and questioned at an airport. There were never any charges brought against Miss McMillan or AH, so these allegations that AH lied to immigration authorities about the true status of her employment status in the US are not admissible and should be excluded under the rule. Again, it's going back to, well, okay, they don't need to be brought in, but they do prove that she is a liar. And she did lie to immigration because, again, there's text messages and emails showing all of this. Which, again, if you remember, it's in all the documents. I will leave the link below to every single bit of evidence that was put forward for the Johnny Depp versus Amber Heard trial, which you will find on the Fairfax County website. So such evidence completely irrelevant to the issues of trial. Whether AH allegedly lied to immigration authorities about the employment status of a UK assistant has no bearing on whether she is lying about this committed by Mr. Depp against her. The potential for prejudice far outweighs any possible relevance. Fourth, at deposition, Mr. Depp cross-examined Miss Henriquez, Whitney, her sister, but never questioned AH, respecting Miss Heard's juvenile driving record, including driving on a suspended license in Texas when she was a teenager. Henriquez at 76, going on for the date, these driving violations were when AH was a minor, and even then are neither felonies nor misdemeanors involving moral turpitude. And even if the convictions could be elicited, which they cannot, in no event may the details of prior convictions be elicited. Such evidence should also be excluded as irrelevant to the issues at trial. Whether AH had speeding tickets as a minor and drove on a suspended license as a minor have no bearing on whether she is lying about this. Again, Elaine has twisted the words there because the reason this was brought forward, which we've all seen, you know, there's been news articles about it detailing back as far as 2016 these articles are coming out, 2015 as well, some of them, and it's regarding the passing of one of their friends when she was actually driving the car. Fifth, at deposition, Mr. Depp also cross-examined Whitney, suggesting her sister was driving a vehicle at the time of the tragic passing of their close friend Logan when they were both teenagers. This is what we were talking about. This suggestion was made even though there is not a stitch of evidence to support this outrageous allegation. She was nowhere near the county in which the accident occurred at the time and was devastated when notified. Thing is, though, people have come out and spoken about this and said that she was driving. Like I said, there's articles all over the internet regarding it. There is no evidence, let alone any charges, convictions that she had anything to do with this. Such evidence should also be excluded as irrelevant to the issues at trial, and even the malicious suggestion that she was driving at the time of the accident should be excluded from trial. Again, with her going on saying there's no evidence, but then saying, well, such evidence should also be excluded. So you do know that there is evidence out there, Ling. You know, there's so many of these things going on is absolutely crazy. But it does go on again saying, you know, claiming suggestion to the jury that she has a criminal record for a lot of stuff. And it's just going forth. And Elaine has made such a big hoo-ha of, right, all of these need to stop. These need to not come here. We don't want to see these. But like I said, I will leave the documents below for you lovely people to read, because we have just come towards the end of it where it just says they just want to get rid of certain things that they should be excluded. And when we go into our next video, it will be evidence respecting either Amber or Mr. Depp's pledges or donations to charities should be excluded. That's what we got for the end of it. Ladies and gentlemen, if you are new to the channel, please like and subscribe, hit that notification bell, and I'll see each and every one of you soon.